Good day to you. This is Graham Paddock with another Paddocks Club video tutorial. Today we're going to talk about internal scheme dispute resolution procedures. We're not talking about arbitration or adjudication under the Community Scheme Ombuds Service, but what can be done within a scheme on an organized basis to deal properly with disputes that do arise. That's today's subject. Let's look at the scope of disputes that can be dealt with internally. An internal procedure can apply to alleged breaches of the Act and the regulations and rules, but it should not be applied to disputes in regard to claims for personal injury or claims for economic loss. Those are best dealt with by the courts. So a scheme shouldn't try and do that with the body corporate in control. Who should be able to make a complaint? Well, I'm going to suggest to you that it can be any owner, any tenant or other occupier, and the managing agent also. These are people, all of whom have vested interests and who should be able, in some sort of formalized manner, to address their complaints with other people within the scheme. And I suggest that it should start off with a written complaint. I'm going to suggest that there should be a standard layout so as to ensure consistency. The same details are given, or the details are given in the same way for every complaint. This helps with making sure that it's dealt with and that it's complete. All the issues are dealt with completely. And there should also be a requirement before somebody even gets this whole system into action that somebody is suffering material prejudice. So you don't want to start this whole process if it's a mere trivial matter. So how should the complaint be made? Well, I'm suggesting that the details should be given. You must set out who are you complaining about, who is the who is the complainant, who's making the complaint. That's the details of the details of the person that the complaint is being brought against. Those must be set out in writing. Now, this is who I am, these are my interests, and this is the person whose behavior I'm complaining about. Now you want them to say what rule or section of the Act or regulation is in fact in issue. They must identify which provision is or are apparently being breached or not being complied with. I think that's very important. It focuses the entire inquiry. Then what are the details of the alleged breach? They must describe what the complaint or breach is about, including dates and times when the behavior complained of took place. You can't just say, oh, he's always doing that. You must say specifically that it happened this often. Then you can get the quantum of the thing. They must describe what action they have taken on a self-help basis to deal with it. What are they trying to do to resolve this complaint? They mustn't come to the body corporate without taking some action. You can't always ask other people to intervene on your behalf. Other people normally have some other agenda, so there must be direct contact required before they ask the body corporate to get involved. Please describe what you have done, who you've talked to, what have they offered to do, if anything. And then if there's if there's to be action, it must be aimed towards something. There must be some proposed solution or action that the complainant must identify. What remedy are you requesting? How do you actually want this problem to be resolved, and is it practical? You must tell us. And finally, there must be some sort of engagement, some sort of declaration, a signature perhaps. I declare that the above information I've given is true, and it's not just something I made up on the spot. And just as important, I agree that the information I've been given can be used and disclosed to others. You can't have the body corporate springing into action to deal with complaints when the whole complaint is given on the basis of secrecy. Okay, so when these conditions are met, what should the body corporate do? Well, the trustees or a grievance committee, a subcommittee of the trustees, should take hold of the matter. They should take that complaint and they should deliver it to the complainant must deliver it to the body corporate, but thereafter the body corporate must take responsibility to deliver it to all the other people involved, and they must, in a timely fashion, convene a meeting to consider this complaint. The people whose conduct is complained of have the right to appear at the meeting and give their side of the story. They also, in terms of our constitution, have the right to be represented at that meeting. And at that meeting, the body corporate or the trustees must attempt to resolve the dispute. They must mediate between the parties. So clearly, They must play an active role in trying to sort the thing out. And then, once having done that and having thought about it, they must record the outcome, including any body corporate decisions and the reasons for those decisions. We decided to act because it seemed to us right, or we decided, no, this wasn't appropriate, so we decided not to act. And that record of body corporate decision should be in a formalized fashion. It should describe the complaint, it should describe the outcome of the internal dispute resolution meeting, the decision of the body corporate in specific terms, and it should give notice that if people are unhappy with the result, that they can then go to arbitration or do whatever else they want to try and think. But that is the body corporate's attempt at curing the difficulty. Thank you very much for joining me in this Paddocks Club video tutorial. If you have any questions on the internal scheme dispute resolution procedure that I've described, please ask them in the discussion forum.